sorry, well, we introduced you at the beginning, but
we?
I forgot, yeah.
Yeah, at the very
We did.
beginning, but not for these guys.
No, for the second
I
group,
was
I
like, for
forgot
these
that
guys,
they
I'm
were
just some
here.
dude sitting.
He just wandered in.
Yeah.
He's a bum, but
Ray actually.
he was interested.
Okay.
Yeah, we weren't notified, but it is.
Oh, no, that's
much-
why I didn't ask anything the first time. I was sitting there going,
It's helpful to hear, break the ice a little bit, so.
Wait a minute, counsel for the opposition has been drinking with one of the judges, I don't know, it sounds a little,
oh, no, that's,
Good comfort here.
that's not even remotely a thing. I've had drinking with judges that I've had cases in front of at
Perfect.
not heavily. I was a young associate. I wasn't gonna sit there, but you know, the judge offers you to buy your drink. You drink, you sit there, and listen. That's just practical advice for you.
Thank you.
The judge ever offers to buy your drink, drink.
Okay, next we're gonna hear from, counsel for defendant, and would you like to say time for rebuttal?
No, thank you.
Okay.
What couldn't everybody was already done. May it please the court? I am Edward Lewis, representing Rockport High School. Rockport prayed to this court for summary judgment, effectively barring Sean Simpson suing the school. The facts of our case hold that March 31st, 2015, Sean Simpson wore a shirt to school. Was a politically charged shirt, had the statement, "Say no to two boobs in the White House." Accompanying the statement was a depiction bearing the likeness of Hillary Clinton, wearing a top that showed a substantial amount of cleavage, with Bill Clinton standing next to her. Sean Simpson, a politically active student, says that he wore this shirt in the hopes of forcing his classmates to think about the upcoming election. Unfortunately, the responses of his classmates caused one of the school officials, the librarian, to seek out the principal and tell him of what had been happening and the negative effects of the shirt. Mr. Norton, the principal of the school, went to the lunchroom kind of to get a first-hand glance at what was going on, and upon him coming to the lunchroom, he witnessed a group of girls knock into Mr. Simpson and drop pudding on his shoulder. In Mr. Norton's deposition, he states that the pudding incident may or may not have been an accident, but it probably was not. As a result of this occurrence, he asked Mr. Simpson to come into his office, and he educated Mr. Simpson on the school policy, dress code policy, which states in part that students may not wear clothing with inappropriate writing or graphic depictions that are lewd, offensive, or offensive to others, or distract from or disrupt the educational experience of other students. Mr. Norton.
Well, counsel, let me ask you this. Is the pudding incident, which is what I'm calling it in my head, is that the sum total of what this administrator knew at the time he had made the decision to?
It is not. I don't think Mr. Norton appreciated whatever else he did here. In his deposition, he also said that he heard that he had been, Simpson, the student, had been called sexist, and also that some nicknames were circulating involving the word boob. But it doesn't say in any of the depositions that he sought after the student to see the shirt or to further his understanding of what was going on with the shirt. Kind of sounds like he heard about it and just left it alone. So upon this meeting with Sean Simpson, Mr. Norton, the principal, gave him the option: turn your shirt inside out, change it, or go home. Sean Simpson decided to just go home, and before he left, Mr. Norton notified him that if he was to wear that shirt to school again, he would be suspended. Less than 48 hours later, Sean Simpson is back in the school with the same shirt on. One of the cases I would like to discuss regarding this particular situation is Barr v. LaFawn. In this case, a school banned articles of clothing with the Confederate flag on it. they banned articles of clothing with that image on it because of a series of situations and events that happened earlier in the school year or throughout the last maybe year or so. The school was actually on a lockdown due to graffiti that was written on the wall with a hit list and names of specific students in the school. Also, there was an altercation between African American males and white males, and due to these reasons, they incited this. They put in place this ban. 2 students wore articles of clothing with that imagery on it, and were told that they were in violation of the school dress code, and as a result, they brought forth action asking that the court basically stop that ban in the school. The court did find in favor of the school, and one of the part of the opinion of the court was that rather than evaluating competing claims that whether disruption occurred in the past, we evaluate the circumstances to determine if the school's forecast of substantial disruption was reasonable. Thank you. It was reasonable. Basically, the court does not require that you show evidence of a reason why a ban is put in place. Only that if you have put a ban on something, your rationale is of a reasonable kind.
Well, Counselor, didn't the powers that be in the Sixth Circuit denounce a ban or denounce a punishment for a Confederate flag shirt in the absence of any showing of that kind of prior hostility in Borough?
Well, not in this particular case. I'm not exactly sure what facts differ, but there were no adverse findings in this case in opposition to any other case. No one cited to this case negatively, and like I said,
Well, counsel, excuse me for interrupting, but the case you're talking about seems like there's quite a bit more physical violence because you have black males and white males in fights, violent fights, and you don't have that same kind of thing here in Mr. Simpson's situation.
Well,
so
no.
we don't have as much reason, the school didn't have as much reason to prohibit the message.
Well, the amount of reason or the type of reason, honestly, was not what was in discussion. Like I said, all they asked is that if you place a ban on an item, you have rationale. I submit that.
Any rationale, dude? Any rationale whatsoever?
No, it does have to be reasonable. So in the case of Sean versus Mr. Simpson versus Rockport, I believe that there was enough of a reason for him to ban the shirt. There was the nipple twisting of students on Mr. Simpson, spitballs. He spoke about him being in his German class, and at the beginning of the German class, a student asked, "Why does Mr. Simpson hate women?" That was the first thing that was discussed. The beginning of that class was wasted on basically trying to find out things about that shirt. The teacher tried to move the class in a direction of something helpful. She ended up talking about something political dealing with Germany, but it was a German language class. And in Sean Simpson's deposition, he states that they did not discuss anything pertaining to German language.
Well, Counselor, in the Tinker case, the dissent noted that an entire math class had been wrecked. And that did not rise to the level of substantial disruption in Tinker. So can we consider that a couple courses going off on a detour would be enough for substantial disruption?
Absolutely not. And it's not that this case ends with the disruption in German class. There were other disruptions, and aside from the disruption, one of his government teacher states that the overuse of the word boob, just in the everyday language in that school, he states that it happens a lot, but on this particular day, it happened more so than ever before. So in accordance with his his comment about the different students using boob references with the situation in the German class, with the situation in the study hall class where the librarian sat and watched the students and said that she had to be extra vigilant in her monitoring of the class, and she allowed 2 students to break the study hall code, which does not allow you to change seats, but she allowed 2 female students change their seats because they showed their disgust for the shirt that Mr. Simpson was wearing. That being the case in all of those situations, it was more than just one class being disrupted, and I think more so to the point, if you do allow for that one class to be disrupted, who's to say that the next day or the day after that or the next week, the same disruption won't happen in that class or another class, then you've lost a whole class worth of work. Another case that I would like to discuss is the Hawk v. Easton School District. In that case, it was a bracelet that contained the word "I heart booby" on the bracelet, and the school wanted to place a ban on this, similarly because of the lewd nature of the word booby. I bring up this case in distinguishing the facts because it just so happens that in that case, the court sided with the students and allowed them to use it and lifted the ban. May I finish the...
Could you finish in that sentence or 2, please?
Yes, the ban did place, the court did allow and lift that ban, but one of the sentences that the court used in that particular situation, they said that if a school can stop a student from wearing an article of clothing of lewd nature, unless it does have a political context, and I maintain that that standard is just too broad, because even if there is a political comment or statement, the depiction can still be too lewd for school.
Okay, thank you, Counselor. We're gonna have a minute of rebuttal, I think, in just a minute. A minute and then a minute of rebuttal. Rebuttal.
Please, the court. Thank you, Your Honor. In the Easton case, which Counselor just discussed, they laid out an excellent standard for judging speech, which is not plainly lewd and indecorous, or not plainly lewd, but rather really indecorous or in a gray area, as perhaps we have here. I think that the counselor was correct when he said that any political speech should not be protected, no matter how lewd it is. And the court there wasn't saying that either. They said that a school can restrict all plainly lewd speech, but ambiguously indecent speech can only be restricted if it cannot be interpreted as commenting on political or social issues. So
Are there several courts that have refused to follow that court's reasoning?
Yes, one of them was the Fort Wayne case in the 7th District, I believe. And I think that they were correct to do so for their case for 2 reasons. First of all,
Please finish the
Thank you.
answer.
thank you, Your Honor. First of all, their facts are very different. They had a middle school, in both cases it was a middle school, but in this one it was determined within the holding that the student body was extremely immature, and that the students wearing bracelets were subject to inappropriate harassment and taunting, and they had a right to be protected. I think that with that sort of occurrence within a middle school, you can find a reason to prohibit the bracelet under Tinker or Frazier. That wasn't the case in Easton, and it's not the case in Simpson. The other reason was more technical and legal in nature. Easton sought to follow the Morse decision under the narrowest Brown standard, somewhat inappropriately, because the concurring opinion in Morse, where Justices Alito and Kennedy stated that we're only joining here because it's not, you know, restricting political or social speech. They were joining the majority, not joining a mere plurality. Therefore, it wasn't binding. So for those two reasons, I think that Fort Wayne correctly did not follow the third district in Easton. However, while it may not be law here with a capital L, it is certainly very good law, as it provides a strong standard to follow when determining how to interpret where the strength of political speech and the degree of lewdness in terms of how, you know, it's a reasonable standard that determines how the court can find. Thank you.
Well done. These good arguments. We've got the bench in a quandary about how we're going to rule because we're convinced 3 different times. So it's official. You are done with the first year of law school. You're done with legal writing. And
That's not true. You're never done with legal writing, people. You every day. Always.
I think I mentioned that at the beginning of the class. Well, yeah, it was a pleasure having you. This is a great class.
Thank you.
I couldn't find a better class to finish.